people through I'm calling it the nuts and bolts of the PPO process. Personal protection orders are one of the main ways that we help survivors obtain safety. And so helping everybody to understand what those nuts and bolts are, and a few tips and tricks and things that I've learned in the last few years of doing this work. So just a brief introduction for myself. So also, if you have questions, feel free to put them in the chat, and Holly and Tara will do their best to kind of monitor those and then jump in when appropriate to ask those questions. If there's any that we missed, you can repeat them at the end if we have time, and I'll try to answer those as best we can. So as far as me, introduction to me, again, like I said, Charlie Campbell, I'm a paralegal and legal advocate at the YWCA. I'm located right downtown, 25 Sheldon. My background, I have a bachelor's of science from Grand Valley State University, and I've got a post-baccalaureate certificate in legal studies from Davenport University. It's an ABA accredited program. I started out my career as the program coordinator at the Legal Assistance Center. That's how I joined the DVCCRT. I was part of this group when I worked there. And since 2016, I've been a legal advocate for the YWCA. I'm also a licensed foster parent and familiar with the child welfare system as well. There's lots of interesting ways where we interact in the domestic violence community with the child welfare system. I would be remiss if I didn't give my disclaimer right at the top. Because I am a trained paralegal, I have this conversation with every client that I talk to. And just as a reminder for the advocates that are working out there with people, Michigan law does prohibit anyone who's not a licensed attorney from engaging in the practice of law. That's kind of nebulous under Michigan law exactly what that is, but generally it includes things like giving legal advice, predicting an outcome. There is an exception, though, when it comes to personal protection orders for domestic violence victim advocates to assist folks in obtaining personal protection orders if needed. And so the reason I'm putting that out there today is to understand that, statewide, I've heard some pushback from some places where they're like, well, I'm not an attorney, so I can't, there's limits on what I can do. It's true, there's limits on what you can do, but helping people pursue personal protection orders is one of those things where there is some protection under state law if you're helping survivors. And so just some tips on that. DV advocates still should not be providing legal advice. That's telling clients what they should do or ought to do, understanding that it's always a client's choice and offering them their options. People shouldn't be promising clients an outcome that their PPO is going to be granted, or they're sure that the judge is going to handle it this way outside of normal process and procedure, or creating a belief that the advocate can represent them in court, basically doing something, speaking to the judge on their behalf, or doing anything other than being there to provide support. So those are kind of the lines that you should be clear with on your clients. And I think most people, it's standard practice to do that, but I just wanted to put it out there to make sure that if you are helping people with personal protection orders, that those are things that you make sure you have an understanding with your client about. Okay, so in the state of Michigan, basically what is a PPO? So a PPO is a civil court order that's designed to prohibit certain behavior directed at a person, which would otherwise be legal. So most of the things that we're prohibiting someone from doing in a PPO are things that are going to be legal unless there's this court order that says they're not. There are some exceptions to that, like assaulting a person, harassing a person, like those things are not legal, but there are a lot of other behaviors in a PPO that we restrict that would otherwise be legal if the PPO wasn't there. It is a court-sanctioned set of boundaries on what a person should not do. And a lot of times when I'm talking to survivors, I frame it that way. I frame the personal protection order as a set of boundaries because a lot of times we talk about boundaries and how to set appropriate boundaries, and how assailants often push past those boundaries and do everything they can to undermine those boundaries. And so talking about a PPO in that context is extremely helpful. PPOs do have criminal penalties for violation. It can include jail time for violating the PPO. Another important point is that a PPO is meant to be a shield to protect the petitioner. It's not meant to be a sword to punish the respondent. It's meant for safety. It's not meant to be punitive towards the respondent. It's meant to keep the petitioner from undue harassment, threats, or abuse by the respondent. Another thing to note is that the PPO is only going to cover the behavior that's explicitly listed in the order. And it's a big part of the tools that we have available to create a safety net for survivors. What a PPO is not. It's not something that's designed to make the respondent leave a joint home that the petitioner and respondent have together. It doesn't prevent a respondent. A respondent is the person that you're getting the PPO against. So there's some terminology I'll use interchangeably: petitioner, survivor, victim, client. Those are all folks that we're usually helping. Respondent, assailant, abuser are all usually terms associated with the other person that we're talking about here. So it does not prevent them from access to their own children. So a PPO is designed to keep the petitioner safe. The family court and a well done family court order is the process by which the relationship between the respondent and their children is governed, and it's not meant to be dealt with in a personal protection order. Again, not to be used as a sword, so that the petitioner can continue to contact the respondent on their own terms. I've seen that happen where I'm working with someone who's the survivor of abuse, but their partner has gotten a PPO against them. And basically it's done so that the person I'm working with has no way to talk back to their partner. So it's not meant to be used as a sword. One misconception about a personal protection order is that it doesn't have any penalties just because it's been issued. Basically, nothing bad happens to you, legally speaking, just by having a PPO against you. Now, if you violate it, then there are consequences, but just simply having a PPO against you does not mean that there's any legal penalty against you at that point. It may not cover all forms of behavior that a petitioner may deem abusive. So there's lots of behavior that we might just not be able to cover in a personal protection order. There are situations that a PPO won't address. And a PPO definitely should never be the sole piece of a survivor safety plan. So if you're doing safety planning with a survivor, trying to help them understand, a PPO is an important piece of it, but it should not be the only piece that the survivor is relying on for their safety. In the state of Michigan, we've got 3 types of personal protection orders. What I spend most of my time in working with the most common. That's the domestic PPO. That's going to apply to any case where you've got intimate partner violence and then a whole slew of other situations. It can be attained against the petitioner's spouse or former spouse, the other parent of their child, someone they've been in a dating relationship with, or someone that they've lived in the same household with. The second most common type of PPO that we see is a stalking personal protection order. That's really meant for situations where there is no romantic ties between the two parties. That does require 2 or more separate incidences and is based on unconsented contact. The most common situation I see that's related to intimate partner violence that a stalking PPO would be used is if there's a new partner involved that is stalking or harassing, but it's not someone they've been in a relationship with. There's also a third type under Michigan law.
Hey, Charlie.
Yeah.
Would you be able to talk about, particularly the requirement to have 2 incidents, and what does that look like for a respondent to actually be able to document, or what does that level of documentation need to look like to qualify for that PPO?
Yeah, so generally when we're talking about a stalking personal protection order, we want some type of clear no contact statement, something where you've communicated to that person that you want them to leave you alone, or you've given some kind of clear signal. It'd be better if it was a clear statement that said, hey, leave me alone. And then you would be looking for at least 2 situations where that person was seeking out contact with you. They confronted you in public, they sent you a message, they made reference to you, they made threats against you to someone else. As far as documentation, I'll get into that when we get into the statement, but basically something that demonstrates that their intent is to have contact with you after a point at which they know, or they've been told, or they've been, a reasonable person should have known that you want them to leave you alone. So that's kind of the situation we're talking about. So it's talking about sexual assault. PPOs doesn't require a prior relationship, is meant to be used when there was no relationship, but a sexual assault has occurred, or you're fearful that it may occur, and it can be used if pornographic material is being shown to a minor. So there's a separate carve out for that under Michigan law. Again, most of the types of PPOs that we're going to deal with in my role in Safe Haven's role in DVCCRT are going to qualify as domestic PPOs. So those are kind of the ones we're going to spend a lot of time talking about today. So in Kent County right now, we currently have 3 ways to file a PPO, 3 ways to obtain paperwork to file a PPO. The court in the last year has rolled out a process through Turbo Court. So you can access this by going to the 17th Circuit Court PPO webpage, where you can go through, and it's kind of like document assembly, goes through and asks you questions, you fill out the answers, and then it gives you the file to download. The PPO office in Kent County is accepting PPOs e-filed through an email address. So you download your documents, you send them into that email address to be processed. Similarly, you can use Michigan Legal Help as well. That's what I typically use with clients when I'm helping them. We go through it. It works really well. I describe it to people like TurboTax. You put in, it asks you a series of questions, you put in the information, it then generates the form for you with all of the appropriate boxes checked that you've answered correctly to. And then you can download those forms to send in, again, an email form to the PPO office. You can also go directly to the state Supreme Court webpage and access the forms in their basic version, their raw version, and print them off, fill them out, and all of that. The PPO office is still open for in-person filing. So even though you can file via email if people are more comfortable physically filing in person, that's an option. PPO office does have computers set up to go ahead and direct you to one of these if you choose to, but you could always still just fill out a hard copy and turn it in that way as well. Okay. Basic nuts and bolts of the PPO process. First step is to complete a petition. So that's going to include things like the respondent's name, physical description, and address. One point here is that we can provide a confidential address for the petitioner. They don't have to reveal their address if the respondent doesn't know it. You are required to include a statement of facts that provide the reasons for the PPO. It should include the things the respondent's not allowed to do, and then can be signed either in person or electronically.
Charlie, do you have to be a resident of Kent County in order to file a PPO through Kent County?
So good question. In the state of Michigan, you are technically allowed to file a personal protection order in any county in which you would like to file it. It does not have to be in your county of residence. You don't have to have any residency requirement to be able to file there, and you can file in any county. So for example, One of the conversations I have with people, especially if they're coming from out of state, so if they've relocated from another state to Michigan, I usually have a conversation with them about where do you want to file, because that may give your assailant an idea of where exactly you are. And so if you don't want them to know, for example, that you're in Kent County, it may be worth it to look at filing in a different county, which you're legally allowed to do, so that they don't get the idea that you might be in one specific area, and kind of narrow down where you might be at.
One other quick question. Do you know whether those computers in the PPO office, are they currently able to be used, or have they stopped that for COVID?
I don't know for sure. I would imagine that the court's still required to provide access to filing. And I think my guess is that the PPO office would prefer that you e-file as well. So I imagine they're still open and available, but I'm not 100% sure on that. Maybe if someone who has more recent experience knows, they can put that in the chat.
Thank you. It looks like somebody said that the PPO office does not have computers for use right now.
Okay.
And one other question, if someone was sexually harassed by a stranger more than once, but doesn't know the stranger's name or where they live, are they able to file for a PPO? I think you need to have an address to serve it.
Well, you don't have to have you don't have to have an address to file, but you are going to need to serve it somehow. The big problem is going to be a name.
Yeah.
If you don't have a name, it's going to be pretty difficult to enforce a PPO if you don't have the person's name. So if it's a stranger, it's going to be extremely difficult. You know the name, but you don't know an address, that you can figure that out, because then you carry one with you and hopefully have someone serve you. Hopefully there's a pattern to it and you can have them served at that point. But yeah, not having a name is going to be a problem.
Thank you.
So I don't know about Turbo Court, but at least in Michigan Legal Help, there is some cues to help you construct a statement, to talk about, what has happened, to ask questions like, did you seek, were you injured, and did you seek medical treatment? Were the police called? Is there a police report number? Was the person arrested? Like, the Michigan Legal Help will do that as you walk through it with them. I prefer, when I'm assisting a client, to work in more of a narrative form. I find those questions to be a bit restricting, kind of breaks up the story a little bit, and doesn't do a good job, from my perspective, in really communicating to the court. So a couple of things about the statement. I'm going to go over some stuff here. So the biggest thing is that, when a client's doing a statement like this, or you're helping a client review this statement or work on this statement, you want to be as specific as possible with the timeline. So, I usually work from the specific to the general. So if they don't remember what day it was, what week was it? Okay. If we don't remember what week it was, what month did it happen? If we don't remember what month, what season was it? Or what year? For a lot of folks, when I'm talking to clients and talking to them about when some of this stuff happened, some of that's really tied to, especially for our female clients, to when they were pregnant, with what child. And they can tie the abuse to, hey, this happened when I was like 3 months pregnant with my youngest child, because they tend to remember those abusive incidents more while they were pregnant, because they're busy thinking about their unborn child's safety as well as their own. And so that's been helpful to kind of fit in that narrative. I always remind the client that whatever this statement says, it's going to be in a public court file. It's not going to be searchable on the internet, so nobody's going to be able to pull it up electronically, but it is going to be in a public court file, and their abuser is going to get a copy of it. And so there's no way to just communicate to the judge what you want to tell them without the other person getting a copy and knowing what you said. So there have been clients that I've had that, quite frankly, haven't put stuff in their petition because they were too afraid to. because they were too afraid that if they said this or said that, that it would only make their abuser angry and would make them less safe than if they didn't get the PPO. So one of the things I try to talk to people about, this was a piece of advice I got on a webinar when I first started this, is to try to tell the story in a very linear fashion. So folks with legal training are taught to view and to think in a very linear way. You know, first this, then this, then this, and to think about things in a sequence of events. The vast majority of people don't think that way, okay? And we talk about this sometimes in trainings around law enforcement too. Like law enforcement sometimes, or attorneys will think, well, if someone can't describe something to me in a linear fashion, they must be lying, right? And so it's an important job to understand that in a PPO, it's helpful. You have to remember your audience. It's just like any writing project you've ever had or had to write for. You have to understand your audience. Your audience is a legal professional. It's a judge, right? And you're going to want to present that information in a way that's going to make the most sense to them, not necessarily what's making the most sense to you. And so I do try, when I'm helping people with it, okay, well, tell me about this. Okay, when did that happen? And then try to make sure those paragraphs are fit in the right linear order so that the story makes sense. So when you're starting off, it's usually an introduction that says, hey, this is how we met. This is when we met. This is how long our relationship was. And that's why I prefer the narrative form over the kind of queued up form from the document generating software, because it gives us an opportunity to be more linear about things than that other piece. We want to make sure that the client's descriptor words are used as much as possible in the statement, because ultimately they're the ones that are describing what happened to them. The only kind of correction that I will make from time to time is around things like choking, where we understand that in our community, we've gotten a lot of education on strangulation. And so helping people understand and talking to a client about, okay, he choked me. Okay, well, what does that actually mean? And what is choking versus strangulation? And what is that difference, so that we can at least be correct on our terminology that way, to make sure that information is correct. But otherwise, it's how the client describes the situation, because their feelings, ultimately, it's about how fearful they were and what happened. And that's the last point, is make sure you're asking and having the client describe how those behaviors made them feel. I can read about someone else's behavior and in my own head think, well, that's not a big deal. That wouldn't make me afraid. But I don't know the context of what that behavior means to that client. And so having them describe, and not just assuming that if someone describes a certain behavior, that everyone else is going to understand how that behavior made them feel. Because the basis of a domestic relations PPO is that the things that the abuser did would cause a person to feel threatened, harmed, harassed, or intimidated. And so their feelings are extremely important when they're communicating in this statement. Some other tips around the PPO statement: try to stay away from discussions or incidents involving the children. Obviously, if it's abuse directed towards the petitioner, that's important, especially even if the children were involved. But remembering that this PPO is not there to serve as a protection for the kids. And so those types of incidents that involve children can be pretty problematic. We're talking about that. Situations where the client was the one who initiated contact can also be problematic. So if there's a history of abuse and the client's going over to the assailant's home and that's where an incident occurs, again, absolutely, the person should be safe in that situation, but it can appear as though the petitioner is the one causing the incident to occur. And so you have to be careful around those to make sure that the context is appropriate. It's important to discuss boundaries that the client may have tried to set that the abuser has not respected or found a way around. So, we all have the right, and this is a conversation I have with just about every client, we all have the right to set our own boundaries and decide what's okay and what's not okay for us. The problem comes in when our partner or our abusive partner won't respect those boundaries. And examples of those then demonstrates the need for why we need the court to become involved, because we need the court to become involved because I've tried to set my boundaries and this person's not respecting them anymore. And I need that higher level of authority to come in and tell them that that's not okay. And so, for example, she blocks him on social media, but he messaged her from his sister's account. I don't want to talk to you. I've blocked you. Well, you're not respecting that boundary. You're messaging me. Now, that shouldn't be the only criteria. That shouldn't be the only thing that happened that demonstrates why you need a PPO. But that's one of those things that is worth mentioning, right?
Hey, Charlie, I got a question about, this is Al Haystack. If there's a PPO that a mom is taken out, and the dad or the person that's taken out is father, and there is this, there's visitation. How does that, I hear you saying that it doesn't keep, a PPO doesn't keep him from the kids, but how is that worked out when, especially if the kids are with mom, and is that, could you just talk about that?
Yeah, so I will get to that later in the presentation.
Okay.
But
Okay.
generally the idea would be then that there should be someone seeking an underlying family court order to address those concerns, so that there is a legal boundary and a legal process set up so that the other parent can still have access to the children.
Got it.
Without having to go between the two of them directly.
Okay.
So one of the other misconceptions about a PPO sometimes can be that it's just limited to physical assault. So you don't necessarily have to limit what's put in a petition to just physical behavior, just physical abuse. Things like text bombing, repeated phone calls, even if they don't contain overt threats, should be mentioned, because they demonstrate, again, that harassment aspect of things, even though it's not a physical intimidation. I also find it helpful to discuss jealous or controlling behaviors that recognize a lot of times judges, attorneys, people involved in the legal profession, their training on domestic violence is going to include things that talk about jealous and controlling behaviors by an abusive partner. And so to the extent that those things have occurred, again, I'm not asking, nobody should be making up stuff to put in a PPO petition, but if those things are happening, it is worth mentioning them. If all of the conflicts and all of the precursors to abuse are, oh, you're texting another guy, like that's not appropriate. Like, regardless of who you're texting, that doesn't mean you should be abused, right? I usually ask people about the scariest incident. It's not very common that the scariest incident they've ever had with their abuser is the most recent incident that's caused them to come talk to me or talk to you. Usually there's a scarier incident that's occurred in the past at some point, and to help somebody understand exactly what that is and how they communicate that can be really helpful, because the most recent incident might be something minor that just kind of is the last thing that pushed them to get help or to get a PPO, but that incident might not completely cover all of the dynamics or all of the fear that they're experiencing. But then I also do want to make sure that you're mentioning the most recent incident. So what I always tell people is, why now? And not in a questioning like, well, why did you wait so long to do this? But in the sense that why, what would we explain to the court as to why you're choosing to do this now as opposed to before? What's the urgency? Why does the court need to do this now as opposed to not, or as opposed to the thing based on the things that have happened in the past? So those are some things that are helpful to make sure you do. And usually that's the discussion. You know, there's the introduction, discussion about the behaviors that the person finds troublesome, and then the scariest incident, the most recent incident, and that's pretty much it for the petition. There are some other considerations though. Again, context is important. Don't assume that the judge will see why something fits in the pattern of abuse. Interference with employment or education can be a big sign for the court. I've heard in objection hearings over and over again, like, don't do something to mess with their employment. Don't do something that messes with their job and their ability to provide for themselves and their family. If there's any special requests in the petition, so if you're going to be asking for things like covering friends or family members, be sure to provide the rationale in the statement. So if you're asking for anything additional, make sure there's reason for it in your statement. Also, anything in the statement the client may have to testify about. So if there's incidents, again, that the abuser will find objectionable, that will make it more difficult for them to be safe or will enrage them, that might be a consideration. Or if there's incidences that they're not comfortable testifying about. So for example, if it's been a domestic violence situation, there's been a whole bunch of physical abuse, but there's also been sexual abuse in the relationship. The client may not be comfortable testifying about that sexual abuse. They may be comfortable disclosing it to you, but they may not be comfortable putting it in a personal protection order petition and having to testify about it.
Charlie, quick question. Somebody wanted to know sort of what your recommendations are about like quality of the examples that you put in a PPO versus quantity. So is it better to have fewer examples with more detail, or is it better to have more examples of like a physical assault or contact, inappropriate contact?
So it's going to depend. It's going to depend on what that is. You know, if there's not a lot of details that can be given, so if it's like the texting and the phone calls and stuff like that, maybe quantity is more important. But for sure, the more details you can provide, the more specific examples, the better. You know, in a domestic personal protection order, it doesn't have a minimum number of incidences. So it's not like stalking. In stalking, you have to have at least 2 or more after the initial no contact statement. In a domestic, there only has to be one thing that the respondent has done that would cause someone to feel threatened, harmed, harassed, or intimidated to qualify for a personal protection order. And so, you know, it really is going to be on a case-by-case basis. But, you know, it's always good if there are incidences to be describing those in full as much as you can. And again, you don't want to go overboard. I mean, we're talking 2, 3, maybe 4 pages, double space typed in a narrative form. I don't think I've ever gone over that in a petition. So it's going to be somewhat brief. And so, you know, multiple incidences where, you know, I've had clients where they've called the police 16 times and then they list all of those specifics and then they don't, you know, they list out this date, this date, this date, this date, but then they don't say much about it. That's not really helpful, right? If we're talking quantity.
Thank you.
Okay, things that are protected on a personal protection order. So there's kind of the statement as far as what's happened and then what you want the court to do about that. So these are some that are taken directly off of the PPO order that are options to select. So generally it's going to cover the petitioner where they live. If there's a specific place that you don't want them to go, regardless of where the petitioner is at, obviously assaulting or hurting the petitioner, there's an option to ask that the respondent not remove any children unless it's allowed by a court order, a custody order. There's prohibitions on stalking, interfering with efforts to remove property from the home, threatening harm, interfering with employment or education, having access So in Michigan, if you are a parent, you're a legal parent of a child, you have every right to have access to your children's information, regardless of whether you have custody of them or not. If you're listed as a legal parent on that document, you have every right to access their school records, their medical records. Any third party who holds records about your child, you have the right to access those. And one of the concerns is that if the child primarily lives with the petitioner, is that the respondent will go to the doctor, for example, and access those records, and it will have the petitioner's new address on it. And then he'll find out where the petitioner is living. A PPO can stop that, can prevent that from happening, can be an order to the third party that says you cannot have access to these records because it will show the address. So that is an option that we can pursue on a PPO as well. There are exceptions, things that apply to pets. And then you can also ask that a petitioner not purchase or possess a firearm. Now, a little note about that, federal law prevents someone from purchasing or possessing a firearm if they have an active personal protection order against them. So even if that box isn't checked on a state order, it'd still be illegal for someone federally to do that, but there's a whole different overlapping of jurisdictions and enforceability that's related to that. So just understand that that issue can get a little complicated. The stalking protections in a PPO, so that would include things like following or appearing within someone's sight. So for example, there may be a circumstance where we take out appearing within sight if, for example, in Al's situation, the two parents want to be able to do parenting time exchanges without a third party involved. Technically, if it says in a PPO that they can't appear, the respondent can't appear within the petitioner's site, it would prevent that from happening. But if the two parties don't want that, or the petitioner doesn't want that, then we can eliminate that as a piece of the PPO. Now, they still can't follow the person, they can't do any of those threatening behaviors, but they'd be able to appear within sight. Comes in tricky like kids, sporting events. If you attend the same church with this person, those are circumstances where we might want to consider taking those things out. Sending mail or other communications to the person, that would cover just about everything. As far as the non-direct contact stuff, approaching or confronting, what they'll tell you, the PPO office will tell you, and what most judges that I've seen say is, the PPO doesn't stop them from being in the same place as you, so long as when they see you, they basically turn around, go the other way. They shouldn't confront, they shouldn't approach you, they shouldn't try to make eye contact with you, get your attention, anything like that. Entering on or property owned or leased or occupied by petitioner, covers them wherever they are. Place an object on petitioner's property. So most commonly, these are things like notes, gifts, that kind of stuff that's left on a car, that's left on at a workplace, that's left at their house. So all of those things could be covered. Someone showing up at a workplace or residence or contacting them by phone. Other considerations, other common options. So all of the things that I've covered are kind of check the box. That language is already written for you on a PPO. From time to time, it's needed to add some additional restrictions there. And these are some of the common ones that we'll add from time to time. So this used to be standard on Kent County PPOs, but when they started using the state forms, this went away as a standard thing. But engaging others to further harm, harass, or intimidate the petitioner. So that would be friends or family members, contacting them, posting things about them on social media, that kind of stuff where it's not the respondent directly doing it. Same thing, posting or encouraging others to post threats or disparaging information regarding the petitioner. So I'll include that when they have concerns about the person saying bad stuff about them on Facebook or on social media. Technically, if they don't send it to the petitioner and they don't tag the petitioner in the statement, they're not making contact with them. They're just posting it. So, adding that clause in there might be helpful to get someone to stop doing those things. As tracking devices have become more popular and cheaper, I've used this one a couple of times to be pretty effective, using technology to determine the petitioner's activities or whereabouts. So tracking devices or tracking apps on someone's phone, shared calendars, that type of thing. It should prevent that. I had one a couple of years ago that I helped somebody file. We put this in there, and 2 days after he got served, he called up the client and said, oh, there's a tracking device on your car. Here's exactly where it is, because I don't want to get in trouble for violating the PPO. Never mind the fact that he called the petitioner and violated the PPO anyway, but at least he admitted that, hey, there was a tracking device there, and here's where it is, so that she could take it off and have peace of mind about that. Another piece that sometimes will happen is disseminating or allowing to be disseminated any images of the petitioner that may be explicit in nature. So sometimes we'll get where the respondent is making threats to release some intimate videos or pictures or something like that, and putting that out there in the PPO may be a helpful way to prevent them from doing that. Because again, there are revenge porn laws out there on the books, but the images might not necessarily be pornographic in nature. They might just be explicit if there's clothing covering all the right places and all of that stuff. So some things to consider as far as additional things to put in a PPO. There are some exceptions you can add in there too. That's what I was saying to Al earlier, could be involving communication regarding children. I advocate as specifically as possible that if you are going to open up a loophole like that, that you be very specific, that it say you are allowed to communicate about the children, and then be very, very specific about what form that communication is going to take. I prefer email because it doesn't demand an immediate response. Some people sometimes will prefer the ease of text messaging, but oftentimes that escalates very quickly, and text messaging can kind of spiral. And so I suggest to clients that they use email as the primary form of communication if we allow any communication at all. Sometimes there can be exceptions regarding use of vehicle if there's only one vehicle, contact with third parties to facilitate communication. And again, you should specify who that third party is going to be. Business communications, cases where the parties own a business together, or one of them runs a business out of the home that they're not allowed to come to anymore. And then other exceptions that may allow for exchange of mail or other personal belongings can all be put in there by design so that those things can happen. So the nice thing about personal protection orders is we can kind of build them to what the client needs, but they are pretty limiting. And you want to build them right the first time, because they're not super simple to change through the courts. If you can usually agree to change some of the terms, but they can be a bit difficult to change once they're in place. Okay, like we talked about before, filing a PPO, I'm specifically talking about in Kent County, you're going to file it through the PPO office located on the 3rd floor. It can be done via email or hard copy. You can attach additional relevant documents if you choose to. So screenshots, police reports if you've got them, not required, but you can include them if you choose to. After filing the PPO, the PPO office will process your documents, send them to a circuit court judge for approval or denial. Once a judge receives it, they've got 24 hours to make a decision on it. It's filed under what's called an ex parte basis. That's how we file all of our PPOs in Kent County. There are other ways to do it, but that's how we do it in Kent County. PPO office will contact petitioner if it's been granted, and then they're typically granted in Kent County for 6 months. Michigan law says that if the court's going to grant a PPO, it has to be at least for 6 months. Can't be for any less than that. Other counties do grant them for longer. If the PPO is denied, the court rules do require the judge to specifically state the reason for the denial. So that in Kent County, we got a little check sheet that the judges fill out that says, hey, I'm denying it because of this reason or that reason, and setting up a basis for if you want to object, to explain and rectify that issue.
Charlie, Dominique is curious, was the interview part eliminated? Was that part of the process that?
So the interview, I'm not 100% sure how they're doing that in COVID. For the ones I'm doing, I'm able to email in. I assume for the ones that are emailed into them, they're not able to do an interview with folks. For the in-person people, really the interview, the purpose of the interview was to help people fill out the order and make sure the order was filled out correctly, because they would give the petition to people to fill out, but the order would be something that they would fill out separately. So they made sure it was prepared correctly for the judge. So I'm not 100% sure how they're handling that now in the time of COVID. Like I said, for the ones that are emailed in, they're not, to the best of my knowledge, contacting people to have any conversation with them about what's in their PPO, because the software automatically generates the order based on how you filled out the petition. Okay. So next steps. If the PPO is granted, the petitioner should pick up a hard copy from the PPO office. And this is where, these steps are where we get into some of the things that are a bit more difficult for the petitioner, and the burden is really on them to ensure that these steps happen. The petitioner is responsible for serving the PPO on the respondent. So it's got to be by personal service or by mailing. Personal service is just hiring a process server, and the cost is usually around $100 locally for that to happen. The other option is to have someone over the age of 18 hand it to the respondent. Just make sure that person is willing to sign something in front of a notary swearing to the fact that they served it. You can also send it certified restricted delivery mail, but that only works if the assailant will sign for the envelope, and if not, it's typically returned in about 4 to 6 weeks. There is no deadline to serve a PPO, but obviously if you're fearful of this person, you want to make sure that they're aware that the PPO is in place as quickly as possible so that they abide by the terms of it. And if it's not served, it can cause issues with enforcement at a later date if you need to pursue that. There is the opportunity for the respondent to file an objection. Court rules say that the respondent has 14 days after being served to object for no cause. They don't have to give a reason why they should be entitled to object. They're just entitled to object. They have that right. They do have to be specific about what their objections are, but they don't have to show that there's a good reason that they should be allowed to object. It's automatic. You can object after 14 days, but you have to show a good cause reason why you should be allowed to object after the 14-day period. Most commonly, what's cited in that situation is, oh, hey, the petitioner's having contact with me. They're having contact with me, and so obviously they're not scared anymore, and the PPO doesn't need to exist. What's supposed to happen is that the hearing is supposed to occur within 14 days of the objection being filed. Those hearings on a rotating basis, depending on what judge and referee you're assigned to. The PPO objection hearings are almost always handled by a circuit court referee. That hearing can be pretty intimidating. The biggest thing to remember is that in this scenario, the burden of proof is on the petitioner. In most other scenarios in court, when you're objecting to something, the burden of proof is always on the person objecting. However, in this circumstance, the burden of proof is still on the petitioner. It's still up to the petitioner to prove their case as to why they need the PPO. There's an initial hearing with the referee that's pretty short. Typically, it's going to take 20, 25 minutes maybe, where both sides are going to kind of give their statements, argue their point, and then the referee is going to decide what to do. The referee could say, hey, there's not enough here to leave this PPO in place. We're going to toss it. It's going to be dismissed. The referee could say, nope, there's clearly enough information here that, no, even if 4 of these things aren't true, one of them seems to be, and we're going to keep the PPO in place. Or they could say, hey, I just don't have enough information. They're both, you're both giving me conflicting stories. We're going to go ahead and set this for a trial, which means the PPO will stay in place while we're waiting for that trial to happen.
Hey,
At
Charlie,
the trial, obviously, the same options are there. It may be left in place, or it may be terminated after the trial. Extensions.
Charlie,
So,
I think somebody was trying to ask a question.
Yeah.
Is
yeah,
that
can you hear me?
Yeah, we can hear you.
Sorry. Just going back real quick to the PPO being served. Do you have any statistics on how many are not served and how long they take to be served?
so I don't take any statistics away from the court period. I know that service is a big problem for our clients. It is a big problem. It wouldn't surprise me that if there's a good portion of PPOs that don't ever get served, and it wouldn't surprise me if it takes a significant amount of time to get them served, but I don't have access to any of that information.
You know if the court keeps track?
I don't. I know they check as these extension or these violation requests come in. That's the first thing they see is if it's been served, but I don't know that the court keeps track if they've been served or not. It's hard because it's not like one of our typical lawsuits, right? Because in a family court case or in a civil case, the summons is issued, and if it doesn't get served, it gets dismissed for non-service, right? So that would be something that's easy to track. I don't know if they've got some easy way to track that internally for the courts. I'd be interested in that information as well. Did that answer your question, Chris?
Yeah, I'm just trying to think. I mean, maybe it's something we can look into. I don't know how you keep track of that, but that would be something, because I'm just thinking with the cost, I know cost has always been an issue. We've been told now with this COVID money, with the new Biden 1.9 trillion, that there's a lot of money out there. Is that something that, in terms of alleviate PPOs, is that a program? Do you somehow set up something where we, pay for service on PPOs, set up a program like that? Now, obviously, that potential as the money runs out, but just maybe if we had a baseline in terms of X number of PPOs are not being served because of cost issues or whatever, and then we put this program in place, and then all of a sudden we get better service, we could justify it, but we got to have that baseline. I don't know how to get that, but something to think about.
Yeah, I can. Holly, I see that you're taking notes. Maybe that's something too, Chris, that we can bring back into the PPO work group or the victim mapping work group and potentially explore that some more as well.
So, other considerations after it's been granted, you can apply for an extension. So a petitioner can request an extension. Technically, you can request an extension at any time after your PPO has been granted. It does require that the original PPO have been properly served on the respondent. There is a deadline, though. You have to file for an extension at least 3 days before your PPO on which you're requesting the extension is set to expire. Best practice, I usually tell people you want to file it about a month ahead of time. Because you can file it 3 days. The court technically, again, the court rules say the court has 3 days to make a determination on it. But I usually want people to file it well ahead of that. If it's 2 weeks ahead of time, probably not a big deal. If you're getting down to a week before it expires, then we really need to be getting things in gear to get that filed. In Kent County, again, the extensions are usually granted for a year, making the total length of a PPO approximately 18 months. But technically, under Michigan law, there are no limits. The court can issue a lifetime PPO. You may have heard people say that or clients ask about that. It is technically possible for that to happen. The practice in Kent County is not to grant an extension that's longer than 5 years, because the piece of the PPO that's really super important is that it gets entered into something called LEAN, which is the Law Enforcement Information Network, which lets the police know that there's a PPO in place when they show up. based on what I've been told, those fall out of lien after 5 years. And so the court has said, we don't want there to be a PPO out there that law enforcement doesn't know about. And so we're going to make you come back to the court at least every 5 years to seek a renewal, or to just let it expire. There is no hearing that's required to request an extension. A judge is going to review that paperwork without a hearing. Extensions can be objected to again. So if the respondent wants to object to the extension, they can. They're entitled to a hearing on it. The law is kind of fuzzy around that because it's been about 3 years since the law was updated that allows for these. It used to be if there was an extension, the law didn't allow for an objection. Once it was determined that the PPO was appropriate, if somebody asked for an extension, the court kind of was in a position where they had to grant it. But the law has changed on that. Usually you want there to be some kind of showing of a continued threat. So if the person's violated the PPO, if they violated it, but you haven't filed violations, that's okay. You may choose not to file violations of the PPO, but they may still have violated it. Those incidences are usually pretty helpful. If there's still ongoing litigation, so like if there's an underlying divorce case going on, but that's still ongoing, those can be helpful in saying, hey, we need the PPO to keep going to kind of keep the situation calm. Unfortunately, if the respondents kind of behave themselves while the PPO has been in place, basically the PPO has worked, sometimes it can be difficult to convince the court that the PPO needs to stay in place, because they say, well, the other person's behaved themselves. Hopefully they've learned their lesson by now, and so let's try it without a PPO in place and see what happens. If a lot of times I'll get clients that come and say, hey, my PPO expired last week and I didn't know anything about it. Can I file for an extension? The answer is no. You have to file for the extension before the first one expires. Oftentimes, people will tell them, well, just go file another one. Well, unfortunately, the law is not super clear on this, but there's probably case law out there, and the general policy is, at least in Kent County, that before you can file for a new personal protection order, you need something new that has happened, some new incident that would require a PPO to be put in place. So you're looking for additional or new incidences that have occurred before you're filing for a new one. So, that's not too bad because, if the respondent's basically leaving the petitioner alone, that's what you want to have happen anyway. But if there are new incidences, then we can go ahead and apply for a second personal protection order, which I've had to do for a few clients because the respondent decided, well, I don't have those boundaries anymore. Let's go ahead and escalate again. Let's talk about enforcement. So enforcement, there's kind of two different tracks I encourage people to walk down, depending on what the violation is. So if it's an in-person violation, always the first line of defense is to call law enforcement. If the person's showing up at your house, showing up at your work, that kind of stuff, law enforcement's your best line of defense in that situation. If the police arrive and the respondent is present, is caught violating the PPO, law enforcement should be arresting that person for a PPO violation. That's one of those that my understanding is most of our local law enforcement agencies have a shall arrest policy on that. If the police arrive and the respondent is not there, which is pretty common, my understanding as we're going through the PPO work group, kind of the response that we typically see is that they're referred back to the PPO office to pursue a violation through that situation. Other violations, so things like unwanted contact, text messages, phone calls, internet messages, all of those things. You can file police reports on those if you would like to, but usually it's not going to be something that law enforcement's going to come right out to your home for. It would be to utilize a normal reporting mechanism through the non-emergency process if you wanted to document it through a police report. But then it's going to be on the petitioner to pursue the violation through the PPO office by filing something called a motion to show cause. So they're going to file for the violation. It's going to be, that paperwork's going to be sent to a judge, and the judge is most of the time going to approve it, say, yup, there's enough here to have a hearing, and they're going to set a date and issue an order to appear for the respondent. That paperwork's then returned to the petitioner. That has to be again served on the respondent. And it requires personal service, which can be difficult if they're avoiding or homeless. You don't know where they're staying, and that is at petitioner's cost. That initial hearing, if you can get it served, that initial hearing, the respondent shows up, the petitioner shows up. That initial hearing is like an arraignment. If you're not familiar with that, basically the judge reads the allegations, says, hey, this PPO was granted on such and such a date, says you weren't supposed to do this. Petitioner saying you did this and it violates the PPO. On this date, you did this. How do you want to, and here's the possible penalties. If I find you guilty, how do you want to plead? And if they plead not guilty, then the court's going to set a trial. If they plead guilty, then the judge can sentence them right there for violating the PPO.
Charlie, are these forms found online as well, or are they only at the PPO office?
So they are, there is a generic motion to show cause available on SCAO, the state court administrator office website, on the Supreme Court website. Pretty confusing to fill out if you don't know what you're doing. So it's best to file through the PPO office. Or you could certainly refer folks over to us if that's something, that's in that more complex range that you want some additional help with. You can send them over, and I'd be happy to help them with it. So if there is a trial scheduled, usually the respondent is going to be entitled to a court-appointed attorney. That's if they can't afford one on their own. The court is then supposed to send over notice of that hearing to the Kent County prosecutor's office to represent the petitioner. In that hearing, the burden of proof is on the petitioner to prove beyond a reasonable doubt that the person violated the PPO. There is a possible sentence. The maximum penalty for a PPO violation is up to 3 days in jail or a $500 fine, or any combination of those two. And multiple violations can be addressed in a single trial. In fact, if there are multiple violations, the court usually likes to handle them at the same time. In reality, those possible sentences are maximum penalties. It's rare to see the court issue maximum penalties in a PPO violation case. What's more realistic, depending on the severity of the violation, would be a couple days in jail, a couple $100 fine, or instituting a sentence but holding it in abeyance until, unless the person violates again, which basically says, hey, you get 3 days in jail, but you don't have to serve that. So long as you straighten yourself out and don't violate again, we're not, if you violate again, then you're going to serve that time in jail plus whatever penalty for a second violation. Conclusion today, things I want you guys to remember. PPOs are often seen as a solution to everything. I don't know how many times people come to me, the police told me to get a PPO, CPS told me to get a PPO, my friend, family member, whoever told me to get a PPO. It's important always to be talking to people about if a PPO is actually going to solve the problem, because a PPO, again, is a tool. It's a tool to help accomplish a goal. Most of the time that goal is safety, but it's a tool. It's not a panacea. It's not going to solve every problem. PPO does not guarantee safety, so there does need to be some other, addressing safety concerns and safety needs. For now, PPO enforcement is largely going to be up to the petitioner. They're the ones who are going to be responsible for enforcing it. The PPO process can be complex. And if you are helping people with PPOs, don't work by yourself. get help, talk to your colleagues. I'm here as a resource. There are plenty of other information out there online. Talk to somebody if you're struggling with how to help somebody appropriately with a PPO. So I've put my contact information here for professionals that are here, and you have more specific questions, feel free to shoot me an email. If you've got clients that need help with PPOs that you're not that just seem more complex than what you can handle, feel free to refer them over to us. I've got the direct line to my department to schedule an appointment, or to our crisis line where they can also schedule an appointment as well. So that's it for today. Unless anybody had some overarching questions or things that I didn't address that they would like me to address, I'm happy. We've got some time here at the end to answer some questions if people have them. So you can put them in the chat, or Holly, if you can call out if people are like raising their hand or something, to have them unmute and ask it verbally.
I'm only able to
Yeah.
people at a time. So if you have a question, yeah, either chat or go ahead and unmute yourself. Great. We are. Well, thank you, Charlie. That was really helpful information, I'm sure, for everyone. Let's see, we do have a question. Do you anticipate the costs to eventually fall on the respondent in the future? Is that a possibility?
At least the initial piece, I don't. At least the initial service, I don't, because that's not the way most litigation is set up with the courts. However, what I've begun doing when we pursue enforcement, when we have to do those show cause hearings, I have been asking, or have had clients ask, because they've asked me about it, like, well, why do I have to do this? Why it doesn't seem fair? So what we've been doing is we've just been asking, like, can we get costs? Like, hey, it costs this much to serve the PPO. Obviously, there was a good reason for it to be there in the first place since you violated it. And can we get the cost of serving it, the violation? So we provide the receipts for that say, okay, well, I paid a process server X amount of dollars to serve this on them, and I paid them again to serve them the violation. Can I get the court to sanction them with costs, or they've got to pay directly back to me? And then if they're found guilty, that's over and above their jail time or their court fines. So we have asked for that in violation circumstances. So that's one of the pieces that we do use to try to hold the respondent accountable.
Susan had a question. She said that you said the petitioner's address can be confidential. How do they do that? Just leave it off the application?
Yeah, so if someone's filling out a PPO application and they want their address to be confidential, it should always read confidential on the paperwork. I don't even put it on the paperwork. I don't trust it to be whited out or anything like that. Then separately, if it's you're turning in a physical copy, I usually write it on a separate piece of paper, write this confidential address, and then write down the person's address. And when I give it to the PPO office, if it's electronically, I usually include that in the body of the email, again with the survivor's permission. I explain that to them ahead of time, but just say, hey, this is a confidential address. And then the PPO office keeps a separate system that's not accessible to the public, where they have those addresses listed, so that if there is anything filed in that case that they need to mail out, that it can actually then get mailed out to that person via that confidential address, because the PPO office maintains the address associated with the case file.
And Brendan can probably speak to this better than I can, but it sounds like if you file for a PPO violation, that the respondent has the right to have access to the police report, which may have the victim's address and contact information on it, and it is not redacted. So just an FYI.
Yeah, so that would involve, I think, the prosecutor in that situation. There's not, I haven't helped with many violations where there's been a police report involved. So, but that would be something that Chris would know, as far as the obligation for the prosecutor to disclose that information.
Under crime victims' rights, we redact the address and phone number of the victim. Unfortunately, we just had a decision by the Court of Appeals that we can't do that for anybody else, though. We used to do it for all witnesses, essentially, and do that, but there just came down a decision by the Court of Appeals within the last 2 weeks that we got to stop doing that, but the victims are still covered.
Interesting. Okay. Sounds
Does
like
anybody know, Chris, you know the answer to this? I talked to PPO people yesterday. When they get the packet of information to send back to the respondent for, which would include those police reports, that they're not doing the redacting. And when we provide a copy of the police report to the survivor to file a violation, we're not redacting it either because we're just providing the police report. Who's doing the redacting?
If it doesn't come through our office, probably nobody. I mean, if it,
That's where I think there may be a ability to do redaction, but I don't think it's actually happening.
So for advocates, that's helpful to know, because then if you're helping someone prepare that, it would be helpful. You know, if the client ever has the police report in there prior to turning it in, having them redacted or helping them redact it may be helpful. That being said, if there's a police report, in most circumstances, that usually means the respondent was physically in proximity to the person, and so they may know where they live already. So that's just something to consider. It gets complex, it gets difficult, and there's lots of different angles to think about when you're in that scenario.
And Dominique had said, if you have a Native American client that needs assistance with paying for getting a PPO served, they do have grant funding available to help with that. And they put their number in the chat to get somebody connected.
Anybody else have any other questions?
All right.
Well, Charlie, I'll throw in one. It's more of just a comment. The thing that you say about, feeling threatened, harmed, harassed, or intimidated, probably some part of that's been true about every intake I've done on a guy who's in for some kind of domestic issue, whether he's been arrested for it or not. And most of the time, what I've seen in our practice in Men's Resource Center is guys have no contact orders that judges have put out. But sometimes there's PPOs, and it's either on the intake or when I hear somebody talk about a PPO, there's often this kind of, sometimes guys go, yeah, okay, I did that. But a lot of times there's like, well, I did this, but I didn't do that. I did this, I didn't do that. And my response to them has been, well, this may have been going on for a long time, and maybe there's some level of exaggeration to make the point, or maybe you don't, you're not owning it, or you're not seeing it, or you're in denial, or something like that. But I'm just wondering, how much do you see where women, victims have, maybe exaggerated a little bit because, gosh, I'm not being heard. People aren't taking me seriously, and so, my hunch is that doesn't happen most of the time, but anyway, just to make a comment about that, because my response to guys has been, it's like you're here for a reason. So usually there's something that's happened.
Yeah, and I guess, the only comment that I would have to that is it is pretty based on what would make a reasonable person feel threatened, harmed, harassed, or intimidated. If
Right.
it's conduct that makes the petitioner feel that way, but a court looks at it and says, I just can't see how a regular person would feel that way. That's why context is so important, right? So if there's a reason why this behavior in particular is making someone feel that way, helping them understand the context of that's really helpful. So, there was a training I was in where they were talking about, an assailant, or they showed a video where an assailant, took off his rings and set them on a counter somewhere in the house. And when she told the police that, the police were like, well, what does that have to do with anything? What does that have to do with the price of tea in China? Well, they didn't ask the right question, right? The context was the reason that he took his rings off is because that's what he does before he punches her in the face, so he doesn't leave any marks.
Yeah.
And so, like, the context is really important in a PPO, and helping a survivor to understand, we need to explain that context here. Don't just assume. So, there's been lots of times where I'm meeting with somebody and I'm going, okay, I understand this behavior. I understand you're afraid of this, but tell me more about that. Explain to me more about it. And then if they're having to explain it more to us, they're definitely going to have to explain it to the judge better, because they can't just assume that somebody's going to understand why that behavior is problematic.
Yeah, and that's something that we see in our groups. It's like a lot of times guys will say, well, I did this, and you hear a context, and you can wonder, well, why don't you see that was not a good thing to do, or that she might have ended up feeling this way or that way. So, I think that's really good. I mean, sometimes guys have a pretty clear knowledge. Okay, yeah, I know what I'm doing, but sometimes guys are not connecting the dots.
Yeah,
and they need to. And
there's also another piece to what you said that I want to make sure is clear, that PPOs can't be mutual. So you can't have so a PPO, when you file a PPO against someone, you can't get in trouble as the person who filed that PPO for violating it. But the person you filed the PPO against, it's their duty to make sure that they're not violating it, not the other way around. Okay.
Right. Yep.
Now, legally in the state of Michigan, the other person can file a PPO against you, and there's nothing legally preventing that. And so if there is a situation where there has been abuse that's been going back and forth between the parties, it may be that the abuse, even though one may be the primary perpetrator, right? And most of what we look at and what our stuff tells us, there's a primary aggressor, right? There's always going to be a primary aggressor, regardless of other things. But that doesn't mean that both parties might not meet that threshold for the court to grant a PPO against both of them, right? If the other person files a petition. So understand that dynamic is possible as well, for the petitioner to file and then the respondent to file back on the petitioner.
Yeah.
Charlie, can I ask a quick question that I probably just need some more education on law enforcement or the legal process, but what's the process like when the violation would be considered maybe a more serious crime? Like it's a stalking, or it was a DV assault that happened. It's reported as a PPO violation, but is there anybody that helps the survivor kind of understand the options, or how does that get sorted out?
So, I mean, the people who would help the survivor understand options is probably going to be us, but that's a determination on law enforcement when they're writing the report, and on the prosecutor on what charges they're going to choose to bring at that point. I mean, the stalking stuff, if there's a PPO in place, that's an escalator for stalking. So if someone's being charged with stalking and there's a PPO or a no contact order in place under Michigan, that's no longer a misdemeanor, which is just basic generic stalking. It's an aggravated stalking, which is a felony. So having the PPO in place does set up set the stage for, if that pattern of behavior continues, it does cause it to escalate to a higher level of a crime than it would normally be.
Thanks.
All right. Well, thanks again, Charlie. I appreciate it. If anybody has any follow-up questions, can they just email you directly?
Yeah. So if you have any follow-up questions, I'll try to answer them best I can via email. And then, if you have clients that need assistance, feel free to send them my way.
Is what you did, Charlie, what you presented, is there like a PowerPoint? Is there, or did somebody say that I missed it?
Yeah, I can send that out to Tara or Holly and make sure it gets sent out if that's how they want to handle it.
Yeah, that'd be great. I'd like to just pass it along to my colleagues at Men's Resource Center in Fountain Hill.
All right. Have a good afternoon, everyone.
Thanks, everybody.
Thank you. Take care.